SJC-11931, Commonwealth v. John R. Fredette.
Ms. Lazar-Moore, good morning.
Good morning. Excuse me. Ellen Lazar-Moore for the Commonwealth. This is the Commonwealth's appeal from an order granting the defendant's motion for a new trial on a charge of first-degree murder. The trial judge granted the motion because she concluded that her failure to instruct the jury on murder created a substantial risk of a miscarriage of justice. This court should reverse the order granting a new trial because there was no merger and no substantial risk of a miscarriage of justice. There was no merger because, viewing the evidence in the light most favorable to the Commonwealth, the jury could have found separate assaultive acts supported.
Only may well be true, but they weren't charged on that. They didn't have to indicate that the assault that you're suggesting in the back of the car occurred. So there might be a sufficiency of the evidence argument there, but the judge never charged them that you have to find an assault separate from the assault that resulted in the death. And so we don't know.
No, the judge did not give that instruction. The defendant did not object. He didn't raise a merger issue. He didn't ask for the instruction. So the question is, was there a substantial risk of a miscarriage of justice? And there have been other cases before the court where the jury were not given that instruction, and the failure to give the instruction was an error, but the court looks to whether there was evidence to support two assaultive acts, and if there was, there is no merger, and so the conviction should stand.
In that analysis, is it solely whether there was a separate and distinct assaultive act apart from the fatal blow versus whether or not the separate assaultive act was sufficient to prove the substantial bodily harm?
It's not totally clear to me. The cases seem to just refer in some ways to a separate violent act, period. And then some of the other cases, particularly a lot of the cases with merger issues, have home invasion as the predicate felony, which has as an element an assault or imminent threat of assault. And so some of the cases do seem to suggest that that assault has to be sort of complete before the assaultive conduct that causes
or there be multiple
killing.
Or there be multiple victims.
Or that there's more than one victim. So here, the judge just found that there was no view of the evidence that could support that there was any injury to the victim prior to the shooting, which I think is just wrong, because there definitely was evidence that...
Take that in order to determine the substantial risk, because you agree that the jury should have been charged as to a separate assault, right?
Yes.
Okay. So the evidence about that separate assault and whether it rises to the level of serious bodily injury, it really actually comes from the defendant's son.
Yes.
And it's not much testimony. So I agree that if your point is there's a sufficiency of the evidence issue, but the substantial risk is about, I don't know, 50 seconds of the trial.
Right. Well,
How is that not a substantial risk?
I think when you're looking at whether there's a substantial risk of a miscarriage of justice, one of the questions is, would the trial, is there a likelihood that the outcome of the trial was affected by the error, something along those lines? And in one of the merger cases, the court, in answering that question, looks to, well, was there a separate assault that was proven that the jury could have found? And if there was, then there was no likelihood that the outcome of the trial was affected by the error. And so if you look at it in that way, then it really does come down to, if the jury had been properly instructed, could they have found that there were two separate assaults? And it's the Commonwealth's position that they could have, and that the judge was just wrong in saying that there was no evidence of an injury to the victim. And I know this case is unusual because the defendants disposed of the victim's body, and the body was never found. So there's no way to point to the victim and say, look, in addition to the gunshot wound, there are all of these other injuries. So clearly, it's circumstantial evidence, but it does have to be viewed in the light most favorable to the Commonwealth.
What about footnote, I think it's 8 in the judge's decision? In fact, the prosecution emphasized that shooting the gun formed the aggravating kidnapping. Then she quotes, while Trotto is driving and he's confined within the car, beating him, and that being the kidnapping, the series of events being the kidnapping, that series of events, the kidnapping that results in his death, the aggravated kidnapping using that gun. Doesn't that cause another potential problem?
I don't think so, Your Honor, because in aggravated kidnapping, either form of aggravated kidnapping, there has to be either a firearm or a dangerous weapon. So when he says it's aggravated kidnapping using that gun, I think if you take the whole argument in context, it doesn't mean shooting the gun completes the aggravated kidnapping.
So that the violence is not the shooting, but rather it's the uninstructed second form of aggravated kidnapping? Or
I'm not sure I understand your question.
why is he referencing or she referencing the gun there? Because the jury is not instructed on the second form of aggravated kidnapping, right? About
Right.
kidnapping with a gun.
Right.
So the whole issue is not that. It's whether there's a separate violent incident, right?
Right. I think she's referencing the gun because the defendant's argument is that the only evidence of injury to the victim was the shooting of the gun that killed him. So I think that's why she quotes that portion of the prosecutor's closing to support her conclusion that there was murder. But I think that if you, again, look at the whole argument in context, it does not mean that. And in fact, the prosecutor made the argument that the co-defendant Sammy's statement to the defendant's son, where he says, we were fucking him up and it got out of hand and I had to take out a gun and shoot him, then the prosecutor argues that the meaning of that was that the beating essentially was so severe that it went so far that they had to kill him and dispose of his body in order to cover up the crime.
Let me ask you about the second form of aggravated kidnapping that
Yes.
wasn't charged to the jury nor requested. Is it your position that the defendant would be liable under a joint venture theory? Because what counsel argues is there's no shared possession of the murder weapon, but is it my understanding that it's more of a joint venture?
Yes, and it was exactly the same at the trial as it occurred. There's no allegation that the defendant personally possessed the weapon, either constructively or actually. The Commonwealth's position was that that occurred as a joint venture, and the judge instructed the jury several times that they could not convict the defendant as a joint venture unless they found that he knew his co-defendant was armed and could or would use the gun in the commission of the underlying felony.
And do we have, following up on Justice Graziano's question, is there any case law that speaks to that prong, which says that the defendant himself or herself need not possess the firearm as long as that person knows that a joint venturer is carrying a firearm?
Off the top of my head, I can't cite a case, but I do know that certainly people can be convicted of crimes that require being armed with a weapon as a joint venturer as long as they are aware that the other person is armed with a weapon. I don't think there has to be a showing of actual or constructive possession of the weapon by the person.
So pragmatically, for you to prevail, if you were to prevail on the second, or the other prong,
Yes.
we would need then to make clear that you can be found guilty if your joint venturer carries a weapon, even if you did not,
Yes, and
as long
again,
as you knew that the joint venturer had a weapon.
right, and that as she instructed, could or would use it in the commission of the crime. And that, again, was how the case was tried the first time around, because even under the form of aggravated kidnapping that was used, there has to be, the kidnapping is committed with a dangerous weapon or while in possession. I believe it says with a dangerous weapon, and then it says also inflicted serious bodily injury. And this other prong of aggravated kidnapping says that the kidnapping is committed with a firearm or other forms of guns.
And following up on that, what is the evidence that Mr. Fredette knew that Mr. Samia had a gun, apart from when he pulled it out and shot him?
There was evidence that the three co-defendants were essentially always together. They called each other brothers. Samia's girlfriend testified she had never seen Samia drive in a car with anyone other than these two co-defendants, and essentially that Samia always had a gun with him. And there was other testimony about a couple of instances where other people testified to seeing Samia with a gun, taking the gun out in front of the defendant, giving it to the other defendant, Trotto. So there was evidence essentially that he always had a gun with him. And certainly, I think the jury could infer in these circumstances where the evidence supported a finding that the defendants went there to get the victim out of the bar and either severely beat or kill him, that certainly if Samia always had a gun, he would certainly have it with him on this occasion.
But that goes to Justice Lowy's question, which is, there's a difference between the sufficiency of the evidence as to that prong versus whether or not we can be so certain that the jury would have found it that there's no substantial risk of a miscarriage of justice.
Well, as I said, I believe that it's in the, I can't recall if it was in the Scott case or the Bell case, but they're both, oh no, Kilburn. In the Kilburn case, there was no murder instruction given, but the court said, because the record clearly established that there were two assaults, one of which merged and one of which did not, there was no substantial risk of a miscarriage of justice because there would not have been a material effect on the verdict if the instruction had been given. And so I think that's the same analysis here, is that if a properly instructed jury could have found evidence of two clear assaults, one of which merged and one of which didn't, then there's no substantial risk of a miscarriage of justice.
But not to be redundant, I'm going to try not to be redundant, but here, it's not that sterile analysis. I mean, Kilburn, there's, I believe, but I'm not sure, what stronger evidence as it relates to the other assault. But here, what you have is a question that may well come out the Commonwealth's way, but a question that's close on whether or not there was a serious bodily injury with a dangerous weapon in the back seat. And so if that's close and they weren't instructed, it doesn't matter, there's no substantial risk because theoretically they could have come back, you're saying, from Kilburn.
As I read Kilburn, I mean, the evidence was the defendant bursts into the home, brandishes a gun, and then shoots the victim. And those are the two assaults, brandishing the gun and then shooting. So really, it's not as though there were two separate victims or two assaults separated by a lot of time. I don't think that that evidence is so much stronger on there having been two assaults.
I can't remember, is Kilburn a home invasion case or what?
It was armed assault in a dwelling.
Armed assault.
And the court didn't look at what was the evidence of the other assault overwhelming. The court just said, essentially, could a properly instructed jury have found these two separate assaults? And yes, as long as they could have, there was no substantial risk of a miscarriage of justice. And I think that that is the same analysis here. And if the court has no further questions, I'd rest on my brief. Thank you.
Thank you. Mr. Hannafy, good morning.
Good morning. May it please the court. My name is Joe Hannafy. I represent the appellee, John Fredette. I would like to point out that this is a case that was went back to the trial court from filing a motion for new trial in this court. It was remanded back. And Judge Kenton Walker was the trial judge. And it's my understanding that the trial judge is granted special deference because she is the trial judge or was the trial judge and has firsthand knowledge. And I think that that's an assessment that can't be overlooked or under appreciated. Her memorandum of decision was very precise, as I would read it, in that she was very careful to outline each of the necessary ingredients to arrive at the issue of whether a miscarriage of justice occurred, the essence is that she looked at whether or not the Mr. Samia was the shooter, and then it has to be determined whether Mr. Fredette was a willing participant in that. When we have evidence, and Judge Kenton Walker's concern was that there was evidence that Mr. Fredette did not participate in that shooting, that he did not want the shooting to take place, and that he opposed it. And it was to such a degree that they had a fight in the car between Mr. Fredette and Mr. Samia because Fredette was so upset with him.
But didn't the jury say otherwise?
I'm sorry?
Didn't the jury really say otherwise? Because if there was no participation in the joint venture, she didn't allow a motion for required finding, right?
She did not allow a motion for a required finding, but
her analysis isn't that there was a miscarriage of justice in the traditional Rule 30. It was a lack of a merger instruction. So you have to focus on whether or not there ought to be a merger instruction, right?
well, she overturned the conviction because she felt that there should have been a merger instruction, and the reason for that is because the question became not whether John Fredette was in the car, but whether the shooting and the act of giving the jury instructions to differentiate between the merger or not merger, that the jury was never given the opportunity to do that.
It's just, there's no issue about that. It was an error not to do that. That's not what we're trying to figure out.
Right.
There should have been an instruction that they had to find a separate assault. Actually, had to be with serious bodily injury and with a
Yes.
dangerous weapon.
Yes.
That's not what this is about. This is about whether or not, when there wasn't, whether there was a substantial risk of a miscarriage of justice.
Well, I would submit, Your Honor, or Justice Lowy, that there is a substantial risk of a miscarriage of justice, and not only because they didn't get that instruction, which they needed to get, and because in order to adjudicate the case or the facts in the case, but they not only that, but they were not instructed on what I believe to be essentially important here is that they were not instructed on the question of whether with respect to the merger, whether the possession of the gun, possession of someone else's gun in someone else's vehicle required an instruction that would help the jury sort that out. In other words, the case law that I cited, the Dooley case and the San case, so both under federal case law and Massachusetts case law, the jury needed to be instructed that in order to find Mr. Fredette in constructive possession of the firearm, they had to be instructed that you have to find beyond a reasonable doubt that Mr. Fredette intended to possess someone else's.
But it's a joint venture.
Yes, but with respect to, joint venture doesn't apply in this case, simply that concept, because the nature of the offense and the whole issue of merger. In other words, we have to consider what the Dooley case said, that in order to find someone in possession of constructive possession of someone else's a gun in someone else's automobile, that due process requires that they be instructed that they have to be, he intended to possess the gun and had the ability and the power of control over that gun.
So your position is that if Mr. X and Mr. Y commit a kidnapping and Mr. X is carrying a firearm and Mr. Y knows that his buddy is carrying a firearm but is not carrying it himself, that Mr. X is guilty of aggravated kidnapping but Mr. Y is not guilty?
I'm not sure I'm saying that. What I'm saying is that the jury needed to be instructed on what the law is in order to protect the accused, that if he didn't have the mental state, the mens rea, the guilty mind, that would assign to a conviction of guilt as a co-venturer, that the law requires that the jury be given the opportunity to make those assessments.
She did instruct as to all the elements of aggravated kidnapping, including knowledge that the joint venture had a firearm. That's the mens rea.
Yeah, but I don't understand how that discounts from the fact that they needed to be instruction on constructive possession when there was evidence that Mr. Fredette strongly opposed the conduct.
I think you should focus on the felony murder, absence of a felony murder instruction, right? So how is your client harmed by the absence of a felony murder instruction? Of a murder instruction, I'm sorry.
Because there was evidence adduced at trial that Mr. Fredette was not in possession of that gun because he opposed its use. In other words, the law protects an accused in that situation because he's just by mere presence, where conduct from a separate defendant spills onto him when he didn't have the mental state for that to accrue.
But I thought, maybe I missed it. I think this Justice Gaziano just asked this. So what didn't Judge Kenton Walker instruct the jury that your client needed to know that the shooter had a dangerous weapon on him? Here it was a gun.
First of all, Mr. Fredette did not have any gun on him.
Well, I understand.
It was Mr. Samia.
I understand.
But it's not just that question. It's a question of the facts of the case and that turn the emphasis on what instructions were required in the direction of fairness and due process. And I think that's what that's what Judge Kenton Walker did. She was very precise in her reasoning and went through each step. I think it was the Randolph case she used to identify each of the 4 steps that were required to establish that there was the commission, the occurrences at trial created a substantial risk of a miscarriage of justice. She was very precise and did it, and in so doing, she recognized that she failed to pick up on the merger argument. She failed, the prosecuting attorney failed to recognize the merger issue arising. In fact, his statement that was referred to earlier, that he himself moved the injustice farther along because he announced that using that gun was created the felony murder.
What is your understanding, the footnote 7, which I read earlier, what is your understanding of what the prosecutor is arguing there? Your sister says it's just taken out of context. What is the last clause of that? What does that mean?
Well, what the prosecutor was trying to explain to the jury, the felony murder aspect of the case, that is that there was conduct in the automobile, and he argued that the conduct leading, all the conduct leading up to the critical moment was evidence of kidnapping. And then he asserted that it was the using that gun was the aggravating element that created the aggravated felony of felony murder by virtue of use of a handgun.
But using that gun created the aggravation in the sense that it's a separate act of violence, or using the gun made the aggravation, even though we're not instructed on that theory? That's the part I get lost on.
Well, how I analyzed it was that he was arguing that there was a felony murder committed. I mean, this was after he argued first-degree premeditated and second-degree murder, and he argued the felony murder based upon the fact that an element, or excuse me, that the use of the handgun created the aggravation under Chapter 265, Section 26. That was the aggravated felony that created the first-degree felony murder elements.
Meaning that inflicted the serious bodily injury, or the alternative theory? That's what I'm getting lost on.
He was using that to argue a significant injury to the victim.
But that merges, right? And you're saying that he's basically using the act of violence that results in the killing to be the separate act? Is that what you're saying?
Well, I think what he's saying, I think Judge Kenton Walker recognized that statement to the jury was misleading, because that there needed to be more assigned to that there were, it required jury instructions that separate out the issues of felony murder and first-degree premeditated murder, that there had to be a distinction made. And I submit that she put that quote in her memorandum of decision because she wanted to be precise in her decision-making, because it was such a serious event for her to have to feel compelled to grant relief.
Do you have any response, before you run out of time, to the Commonwealth's position on, as it relates to the Kilbourne case, that in order to measure substantial risk of miscarriage of justice, we're looking to see whether or not there's sufficiency of the evidence as to a separate assault?
As I remember the Kilbourne case, it wasn't that there were two assaults on the same person, that there was assault, there was a pushing and shoving of other people in the apartment, and that constituted a separate and distinct act of violence. By virtue of a home invasion, it's aggravated because you assault somebody in the apartment. That happened separately and apart from the shooting that happened, and so there wasn't any overlap of elements in that case, and so I think that can be distinguished, Your Honor.
Okay, thank you.
And I rest on my brief. Thank you very much.